Welcome to Simply Legal. I'm your host, Geraldine Warren, longtime Medfield resident and practicing attorney here in Medfield. And as many viewers are aware, my office is in the heart of Medfield behind Town Hall. Each month, Simply Legal presents a topic that we hope the viewers find not just interesting, but also useful. And I'm sure today will be no exception. The topic for today is estate planning. We thought that this was a perfect time to present this topic since many of you are getting your documents ready to do your taxes and are probably thinking about your asset protection. I'm very fortunate to have with me today my associate, Erin Fontana. Welcome, Erin.
Thank you.
Do you want to tell the viewers a little bit about yourself?
Sure. I grew up in Connecticut. I went to college in Virginia at Washington and Lee University. Then I came up to Boston College Law School. Met my husband on the first day of school and never returned to Connecticut. So after graduating, I clerked for the chief judge at the Delaware Bankruptcy Court for a year. Then I worked as an associate at Ropes and Gray in the bankruptcy department for about 6 years. And then I took a break to raise my 2 small children. And now that they're in school full time, I decided to come back, and now I'm working in Medfield as an estate planning attorney. So.
Well, again, welcome, Erin. So as the viewers are aware, we're going to be doing a program on estate planning, and I just want to give you what our outline will be so you can follow us. Since our program is very a conversational type program, I just wanted to give you an outline so you can kind of follow us. And I know there are times when we will be going back and forth, but we're going to begin with wills and then trusts, and then we're going to talk about the other documents we include in an estate plan: durable power of attorney, healthcare proxy, advance directive, declaration of homestead, and sometimes if you have minor children and are planning on traveling, we include the Massachusetts temporary agent form, or some people know as the emergency guardianship form. And then finally, I'm going to talk about the crisis and advanced planning for the elderly. That in and of itself should be its own program, but I just want to mention it so that people are aware that there are trusts that might be involved in that as well. So to begin, an estate plan is basically documents that will help you, give you peace of mind to know that the people you want to leave, the assets that you've accumulated through your lifetime, will go to people that you want it to go to. If you had died without an estate plan, then you're dying intestate, and the state of Massachusetts will determine who takes your stuff. So you don't want that to happen, and you want to make sure that you have an estate plan. An estate plan can also minimize estate and gift tax, and also it can decrease the cost of administration. So Erin is going to begin by telling you what is included in a will and some of the provisions that may be in your will, and also what the requirements are in Massachusetts for a will. Before she begins, though, I want to mention that you may hear three different wills. You may hear the basic will, which she will begin with, and then there will be the pour-over will that we will talk about in conjunction with trusts, and then a holiographic will that is actually not valid in Massachusetts, but there's some nuances with that. So again, Erin, do you want to go ahead with that?
Sure. So a will, in my opinion, is a document that anyone over the age of 18 should have, particularly if they're married, especially if they have minor children. It's a legal document that directs the distribution of your assets upon your death to beneficiaries of your choosing. As you said, if you die without a will, the state of Massachusetts decides who gets what and how much. And in this day and age, with the different kinds of families and living arrangements, it's just better if everyone has a will in place to give them their peace of mind. So anyone over the age of 18, as I mentioned, can make a will. It has to be written, cannot be oral, and it needs to have 2 witnesses. So handwritten wills are valid. However, they're not recommended. They have to be witnessed. But there are issues with legibility, and if the court can't read the will or if the will gets challenged, it goes against the scriber, the person who created the will. So it's highly recommended that if you want to have a will done, you contact a lawyer, you have it typed up. So the
distinction between a holiographic will, which is just a handwritten will that you sign, whereas you can do a handwritten will and sign it, but it has to be witnessed in Massachusetts by 2 people. So that's why we don't have holographic wills, because you can do a handwritten will in Massachusetts, but it does have to be witnessed by 2 people. So we just wanted to make that clear, because sometimes people don't understand. They think, oh, if it's handwritten, that's holographic. But If it's witnessed by two people, you can do a handwritten will. But again, as Erin mentioned, it can be really messy, because if there's a question about your handwriting, someone is objecting to a term in your will, then it's going to go against you if the court can't decipher what you had written.
Right, and also handwritten wills just bring up questions, more questions as to the validity of the will. I think they're easier to challenge. If they are challenged, you have to find the witnesses, unless the witnesses' signatures have been notarized, which probably, is not the case if it's handwritten. So it's just better to have the will typed up and witnessed and notarized. So. In the will, in addition to deciding who gets what, you get to appoint your own personal representative, also formerly known as an executor. Now they're called personal representatives. And that is the person who will direct and manage your estate. They are responsible for going to the court, liquidating your assets, making sure the beneficiaries get the distribution that you provide for in your will. But perhaps the most important thing that you can do in a will is provide guardians for minor children. A lot of people my age or younger perhaps don't want to think of the circumstance where they need to have a will or guardians for their children. However, I have to say, if you don't appoint guardians for your children and something happens to you and your spouse, the courts, again, will decide who gets your children, and again, may not be what you would have chosen. So. Those are the three benefits, I think.
Can you, in your will, say, I would like my children to live in the town of Medfield if something happens to my husband and I?
No, you would choose who would raise your children. You would say, in the event something happens to my husband and I would like my mother to be the guardian of my children. They'll be responsible for their care, custody, and property. So you cannot put restrictions on the guardians. I have requested that my guardians...
So you can request.
You can request it. It's not binding on the guardians. I've had discussions with my guardians. The plan is for them supposedly to move into my house in Medfield. Not everybody can do that.
As Erin was saying, it's really important not to put off having a will drafted because you don't know who your guardian is, because you don't want the state of Massachusetts making that determination. And the other thing that I wanted to mention was the code was recodified in March of 2012. It went into effect. And we now have a section in the will that's called the memorandum. And do you want to just explain to the viewers about having a memorandum?
So if you would like to provide certain assets of yours to go to specific people, you can attach a memorandum to the back of your will saying, I'd like my diamond necklace to go to my daughter. I would like my, this painting to go to my sister. So formerly, you used to actually have to do like a formal codicil to amend the will. But now, as far as the distribution of certain particular assets, it's easy. Even after the execution of your will, you can just attach a memorandum, sign it, date it, and add specific distributions, which makes things a little easier and less costly.
So just to review, in the memorandum, it's a line in the will that we include so that if you do choose at some point in the future to add, as she said, an asset, but just so you know, it has to be a tangible personal asset. It has to be something tangible. It can't be real property, it can't be money, can't be securities, it can only be tangible personal property. So if there's something like personal to you, like a ring or a watch, that you want to leave to a beneficiary, all you do, as Erin said, was date and sign it, and that's legally binding on the personal representative to go ahead and do it's not a wish anymore, to go ahead and give it to that person. So that's just something new when the code was recodified. And now, can anything in the will be distributed through the will, or are there other things that are not distributed by a will?
Certain of your assets generally do not pass through the terms of your will. Those assets include assets that are jointly held. Generally, retirement plans do not pass according to the terms of a will. Certain life insurance policies, anything that's payable upon death, and assets that are in trust. So there are many types of assets that don't pass through your will, but that doesn't mean that you shouldn't have one, because there are always assets that you're going to forget, and again, there's all your tangible personal property that you want to distribute, and that will all pass through your will. So.
Okay, great. And as she was saying, with the joint property, if your name is on a bank account with your spouse or with someone else, then that's called right of survivorship. The same thing with your real property. If you have a deed where you're on it with someone else as a joint tenant, then it's right of survivorship. If you hold the property as tenants in common, that's not right of survivorship. So those are things that you really should talk to your attorney about and make sure that when you're drafting your will, you know whether you hold that property jointly or tenants in common. And as she said, anything with a beneficiary on it, a 401k, an IRA, those are outside the will. Anything that is taught in trust that might say ITT or TOD with transfer on death or payment on death, those are outside the will. But there are many assets that will go through the will, so that's something that should be done, definitely. And I also mentioned the pour-over will. The pour-over will comes into effect when you have a trust. And we always include the pour-over will in case you don't name something into your trust. And it's exactly what it says. It would pour into the trust. So what we do is we'll designate who the tangible personal property will go to, and then anything that's not tangible the rest and residue is how we call it, will pour into the trust. So we're going to begin to talk about the inter vivos or living trust. Do you want to begin with the trust?
I do. I just wanted to make one other point.
Sure.
If you hold a property as a joint tenant, if the joint tenant predeceases you, then that property will pass according to the terms of your will. So
good point.
That's just something to keep in mind because you don't ever necessarily know who's going to pass first.
And on that same vein, if your beneficiary you named has predeceased you,
yes,
and you don't put in a new beneficiary on your life insurance or your 401k, then that too will go through your will.
Yes, it will.
So that's a good point. So now let's talk about the inter vivos trust.
Okay. The inter vivos trust is a document that comes into effect the date that you sign it. It is a living trust. Normally you would appoint yourself as the trustee. Sometimes people appoint themselves and their spouses as co-trustees. As the trustee, you can manage and direct your assets as you wish. The trustee's job in a trust, it's a fiduciary role, is to manage the assets for your benefit during your life and then for the benefit of whoever you designate as beneficiaries after your death. Upon your death, a inter vivos or living trust will become irrevocable. So the trust allows you to take assets and put them into the trust to be held in the future for maybe your children. So let's say you were older, you had a house, but it was a vacation house. You could put the vacation house into trust so that it would be owned by the trust and therefore would not be part of your estate when you pass. That more probably has to do with estate taxes, which I know we're not really getting into. But so the trust allows you to get assets out of your estate but still maintain sufficient control over them during your life. And as I mentioned, a trustee is appointed. It's a trustee of your choosing. The trust provides for a successor trustee in the event that you become sick or incapacitated. Trustee cannot use your trust assets for their own benefit. They have a fiduciary role to the beneficiaries. They have to account to you. They have to account to your beneficiaries. And as you mentioned, it's a way to protect your assets for the benefit of your children during your life.
And also it's a very private
oh yes.
It's a very private document. When you have a trust, unlike a will, which goes through the courts, so it's public, the public is aware of your trust because everything is filed with the court. But with a trust, it's a very private document. So that's another reason why people sometimes choose to have a trust. Another reason why they may choose to have the trust is because there is no court supervision. And so upon your death, it does become irrevocable, but your trustee can access any of the assets because there's no court supervision. So that's another reason why sometimes people prefer the trust, to avoid probate and also because it's a private document. As Erin mentioned, we are planning on having a separate program on estate taxes, but just to let you know that in Massachusetts there is a $1 million estate tax per individual, and there's a federal 5.34 per individual, which also changes with inflation. So we wanted to let you know that the trust is a way to hopefully minimize the estate tax, and in some instances it may even eliminate the estate tax. One other thing it may do is minimize the cost of administrating because you don't have court supervision. And again, these are inter vivos trusts that we're talking about, the kind of trust that you can manage during your lifetime. And at your death, as Erin said, it does become irrevocable. We have talked about irrevocable trusts in the past. We had a month ago one on supplemental needs trusts, and as I mentioned in the crisis and advanced planning, I'm going to talk about some irrevocable trusts in that instance as well. But why don't we get back to, so in the trust you have the trustee.
Yes, so you'll name a trustee. As I said, most people name themselves during their life. They have a co-trustee with their spouse, and then you name a successor trustee, and then the trust provides for the appointment of further successor trustees in the event they become sick, incapacitated, resigned. So it's not a document that you have to recreate every time something happens. You can provide for circumstances in the trust. The other reason it's a great document is you can deal with your beneficiaries, set forth who your beneficiaries are. You can deal with them as a group. But if you have children, let's say you have some who are more responsible than others, you can really use the trust to carve out exactly what you would want as far as when they receive lump sums. You can say that the children are provided for, a certain, they get the income every year, but let's say one of them needs money for school or one of them gets sick. The trustee has the discretion that you set forth in the document to use your assets to take care of your children as needed. Let's say you have one that you don't, necessarily trust with money. You can say, they don't get a lump sum until they're 35, but even then, if the trustee, if they have a problem or if they may not be in the right state of mind to accept that lump sum, you can give the trustee the discretion to withhold that until they are in the proper state of mind. So
that's a good point, so that in the trust you have that ability to decide when your children, can take. So even when they're not minor children, usually we provide in our trust, like if they're under 25, that the trustee will have that discretion if they need money for college or if they need something for health and maintenance, that will be taken care of in the trust. But then we also provide that if they get to a certain age, they may get a distribution, and that isn't necessarily a discretionary distribution, but one that the trust provides that the kids will get. Sometimes it will be 30, or sometimes it'll be 35. And we've even currently have clients who've come in that have older children and want to wait till they're 40. So that trust allows them to do that.
yes, and I should also mention that the trustee, while they cannot use the assets for their benefit, they are entitled to reasonable compensation. So if you choose a successor trustee who you don't want to burden them, they are entitled to a reasonable compensation. You can also provide in the trust that they have to hire a professional trustee to assist them if your assets are, if it's a complicated portfolio and you're concerned about their ability to administer the assets for the benefit of your beneficiaries.
Yeah, and that's a really important part that we always tell them. And they want to name even one of their children that's older, that they may want to say like 60 days after my death or after the surviving spouse passes, that they go ahead and hire a professional administrator to go ahead and help with the distributions or the investments.
Yes.
Because if the trust is going to keep going, they want to have someone to help them with investments. That's a really good, important point. So moving on, so now we have the wills and the trusts in place. Then there are other documents we include in the estate plan as well. And the first one I would talk about is the durable power of attorney, which is a document that you should have during your lifetime. And it's called durable because it goes into effect when you sign it, and then if something happens to you and you're no longer competent, it still goes into effect. So do you want to just go over the terms of a durable power of attorney?
Sure. So as you mentioned, when you sign a durable power of attorney, it takes effect immediately. You name your attorney in fact. My spouse is my attorney in fact. And the power of attorney sets forth everything that he can do in my name. For example, if we were buying or selling real estate and I didn't want to attend the closing, he could sign all the documents for me. If I were in an accident and in a coma, or if I got stuck outside the country and we needed to sign something, taxes, whatever, he can sign my name for any purpose set forth in the durable power of attorney. He would have to show the durable power of attorney. Like you couldn't just go to a bank and say, oh, I'm so-and-so's attorney in fact, I want their money. But you do have to prove that you're their attorney in fact. So when you do sign a durable power of attorney, you should always let your attorney in fact know where they can find a copy of it. And again, it's another document in which you can appoint a successor, so that if something happens to your attorney in fact, or they are also unavailable, your successor attorney in fact can find the document and make decisions on your behalf.
And I think one of the important things to mention to the viewers is that when you do name a successor in a power of attorney, a lot of times people get concerned because it isn't their spouse, and many times your spouse will be your alternate ego, which is what we call the attorney in fact, because they're allowed to do anything with regards to your financial well-being. It could include paying your mortgage, your taxes, anything that would have to do with your financial well-being would be that attorney in fact's duty. So the successor is usually someone else that you name that may not be a family member, or it may be, but it may be someone that's a little more extended, an aunt or a sister. And so you want to understand that that person cannot go ahead and act unless the first attorney in fact is not available, and they have to show that they're not available by showing that the person either resigned or was ill or has already predeceased the person that named them attorney in fact. So it's not just so a successor can go in and act as your attorney in fact. Sometimes that comes up because it concerns people, but we do like to name a successor, especially if it's a spouse and you're traveling with your spouse.
Yes. Also, I should say that that's another document that anyone 18 or over can
Good
and
point.
should have. A lot of people don't think that their, college-age children need to have these documents, but you just never know nowadays. So, some 18, 19-year-olds actually appoint their parents as their attorneys, in fact, to
That's a good point.
Do things on their behalf if they become incapacitated or.
I know for myself, Erin, when my children turned 18, I had them do a durable power of attorney and a healthcare proxy, because it's just, people don't realize that once your kids are 18, that you lose that ability to access their accounts if your name isn't on it, or even if they're in college and something happens to them, you can't get their medical records. So it's really important to think about that once you have a child over the age of 18, to talk to them about doing a durable power of attorney and a healthcare proxy. And that's something we strongly encourage. So now we're going to talk about the healthcare proxy. The healthcare agent who would be named in your healthcare proxy, unlike the durable power of attorney, can only make a medical decision for you if you are unable to make that decision, and a doctor has to say that. So unlike the durable power of attorney that goes into effect when you sign, the healthcare proxy only goes into effect when you can't make your own medical decision. So do you want to go over a little bit more about the healthcare proxy?
Yes. So as you mentioned, it only goes into effect when a doctor determines that you cannot make your own decisions. Often, again, people choose their spouse as their healthcare proxy, a sibling as a successor healthcare proxy, and that person is able to make all the decisions regarding your care on your behalf. So the healthcare proxy will give them the authority to make decisions with respect to your medical care, interventions, what the doctors may not do, and the doctors are bound by their by the proxy to act as if they were speaking on your behalf.
Because again, the proxy is a legally enforceable document, and we want to make that very clear that that's a legally enforceable document, as is the durable power of attorney. Now, the advance directive that we mentioned is not a legally enforceable document in Massachusetts, but it is a directive. So unlike some firms, but we give you a separate advance directive, because including it in a healthcare proxy can be confusing because it's not a legally enforceable document. So an advance directive is a directive that says to the hospital or the doctor that if certain things happen, you don't want to have measures taken. So if it's determined that you're not going to come out of the state you're in, if you're in a coma, and it's determined that you have a flat EEG, or the doctor has said that there's no way this person is going to come out of the condition they're in, that you don't want to have a ventilator, or it may be a feeding tube, or it could be antibiotics that are going to keep you alive. And that's only if it's determined that those things will just keep you in the state you're in, but won't help you improve. So then that's the advance directive. And again, you would name an agent that would act as your healthcare agent with the advance directive, and we also name a successor with that document as well. all our documents we include a successor, because you never know if you're traveling with the person you named as the first person or something happens to the first person that you've named. We always name a successor.
I should mention also, as far as the healthcare proxy is concerned, oftentimes you'll go to the hospital and they'll hand you a healthcare proxy. And you're in the hospital for a reason. You're in pain, who knows what's happening. You may not have a chance to read it carefully, maybe you do. Often the healthcare proxy they hand you at the hospital only pertains to the actual reason that you're there for that particular visit. So it's just a good idea to have a healthcare proxy done in advance when you're clear-headed, calm, you know exactly what it says, it takes care of every possible scenario, and then you can go ahead and give a copy to your healthcare agent, to your doctor. If you have to go to the hospital, someone who knows where it is can fax it to the hospital. So it takes care of every situation.
And again, that's a good point. Whereas with the durable power of attorney, we tell people that if it's not your spouse that you've named as an attorney, in fact, you may not want to give it to that person that you did name because it goes into effect when you sign it. But you want to tell them where it is. The healthcare proxy is different, where it doesn't go into effect unless a doctor or it's determined you can't make a medical decision. So we encourage you to go ahead and give a copy of the healthcare proxy and advance directive to your healthcare agents, to your doctors, and bring it with you to the hospital so that you don't have to continually sign healthcare proxies at whatever hospital you go to. So that's an important point that you mentioned, Erin. There are two other forms that we wanted to talk about that we had mentioned in the outline, and that was the Declaration of Homestead that we include in our estate plan, and also the emergency guardianship form, or in Massachusetts, the temporary agent form. So first I'm going to just quickly mention the Declaration of Homestead that we include, and even if you don't do an estate plan us, we would do that for you free of charge. There is a filing fee of $36. What a Declaration of Homestead does is it protects your home from an unsecured creditor. So they can't attach or execute a judgment against your home if they're an unsecured creditor. That doesn't mean that you can't pay your taxes, you can't pay your mortgage. Those are secured creditors. The bank is a secured creditor. The code for the Declaration of Homestead was recodified also, and in 2011, they now allow trusts to have a declaration. If you have your house in a trust, you're allowed to have a declaration of homestead. You also get an automatic $125,000 homestead if you don't actually do the form and file it. But if you do go ahead with the declaration of homestead, you can protect your home up to $500,000. If you're disabled or over the age of 62, you have the ability to sometimes stack, so it goes over the $500,000. So I really highly advise going ahead with a Declaration of Homestead if you don't already have one, and we can certainly check your property and see if you do, and then it's just a $36 filing fee. So finally, the other form we wanted to talk about was the temporary agent form in Massachusetts, and Erin's going to go ahead and talk about that.
So as Darlene mentioned, you can now fill out a temporary agent form in Massachusetts. It's good for 60 days. And this is the situation you would probably want a form like this if you had minor children, and if, let's say, you were going away for an extended period of time, or if you're going into the hospital, perhaps. So as I mentioned, it's only good for 60 days. You would appoint a representative to become basically effectively the guardian of your children for 60 days, their care, custody, property. It's interesting, by signing the form, you are not, the representative cannot consent to their marriage or adoption. One would think that that was just automatic, and you can also further limit what they can do in the form. If it's more than 60 days, for example, if let's say you go away, or if you get, God forbid, or in a coma, either a new form would have to be executed if you were capable of doing it, or if not, then they would have to go to court. So I think of the situation where, my parents, when we were children, went away and left me with my brother and I with my aunt for a week, and my brother fell and cut himself, and I got to watch my aunt and my grandmother freak out for a few hours about how they were going to deal with his injury, because it was obvious that they couldn't take care of it after my grandmother tried to butterfly it for hours. But yet they didn't have any document saying that they could take him to the hospital or whatnot, So this is just a situation, another peace of mind situation. And again, it does not have to be the guardians that are set forth in your will. It's just for 60 days. So let's say, you appoint your brother or sister as your guardians in
the
your will, but you're leaving your children with your parents, you can make them the guardians for 60 days. If something comes up and they can get a hold of you and you don't agree with whatever they want, let's say your child's in the hospital and do they do this procedure or that procedure, you still have the right as the parent to trump whatever the temporary guardian wants to do. You have the right to make decisions, and if you disagree, the parent's decision dominates. The other thing that you can do is terminate it. So let's say you get back in less than 60 days and you're not comfortable, you can terminate it in writing.
And how do you terminate it in writing?
You send a letter, sign it, you send it to the temporary guardian, and then you also would send it, to the school, to the doctor, to whomever was, Again, probably not a situation that's going to come up, but will give you a peace of mind if you're,
It's just one more thing that we give people peace of mind for. And I think that example at the hospital is a great one, especially nowadays with all these privacy acts.
Yes.
And that you have to sign HIPAAs and, the healthcare proxies. And so that's a really good point.
Yes, and also, the last thing you want is for your child to be in pain or in need of something, and somebody has to go to court, to get a temporary guardian appointed because they can't get a hold of you, and who has the authority to make decisions on behalf of this child.
So finally, the last piece we were going to talk about was advanced and crisis planning. That's an important part, and we wanted to have a separate program on that because there's many elements to that. And I do want to say, though, if anyone needs advanced or crisis planning with the elderly, they really should go ahead and find out if the attorney is a member of the National Academy of Elder Law Attorneys, and specifically our Mass chapter, because we really keep abreast of what's happening with the elderly. We have a lobbyist at the State House that's letting us know any bills that are coming down, whether we want to promote them or not. And I just think that if you need advanced or crisis planning, an elder law attorney would be the one to go to if they're a member of the National Academy of Elder Law Attorneys. And again, some of the things you may do with advanced planning are the irrevocable grantor trusts that you may put maybe your house in an irrevocable trust and you can still keep a life estate, but you have to be very careful of the wording because sometimes these trusts, the Mass Health is not going to allow those trusts. And there is a 5-year look back. It used to be 3 years in Massachusetts. It's now a 5-year look back. So you have to be very careful with these trusts and with determining what you might want to transfer because it's a 5-year look back on any transfer that you make. So again, that should be a whole separate program, but if you have any questions, feel free to call Erin or myself at Warren Law or any other attorney that's a member of the National Academy of Elder Law Attorneys. Again, I had mentioned in probate, we would like to do a program on probate because the code had been recodified and had gone into effect, all the codes with regards to probate in March of 2012. So there are many changes that we thought the public would like to be aware of. That there's now an informal probate, the involuntary administration limits have changed, and the wording again, as Erin had mentioned, it's no longer executor, it's personal representative. If you die intestate, it's per capita, not per stirpes. So there are a lot of things in the probate sections that we'd like to talk to you about. So what I would say to the viewers is thank you for tuning in today, but please tune in again because this is Simply Legal.
Production support provided by Medfield.tv. Access to our community.